Hello, everyone. I think we'll get started now. Thank you for joining today. My name is Robert Lowe. I'm an attorney at Holland & Hart, and I'll be speaking to you today about the Affordable Care Act non-discrimination rules, which were actually implemented almost 2 years ago to the date, May 18th, 2016. I suppose I should have held this webinar tomorrow, but in any event, happy to speak with you today. Now, if you have any questions during the presentation, please feel free to type them into the question and answer box at the bottom right corner of the screen, and I will try to answer them by email to you after the webinar. Per the usual disclaimers, this presentation is for educational purposes only. It's not legal advice, nor does this make you my client or me your attorney. You should also have been sent some written materials, this PowerPoint, along with some other articles, guidance, and alerts that provide more detail on our topic today. So let's begin. I'll be talking to you about the non-discrimination statutes in general, and specifically about the Affordable Care Act non-discrimination rules. We'll go through who it applies to, the notice obligations towards persons with limited English proficiency, your obligations towards persons with disabilities, and then enforcement, who enforces these rules. And we'll end off with service animals and what obligations you have as a covered entity regarding service animals, and then we'll talk about action items, how to make sure you are in compliance, where to go. So I'll be focusing on the ACA non-discrimination rules as they apply to healthcare providers, not health plans, in this presentation. And in addition to the ACA non-discrimination rules, which I'll just call the rules, there are other discrimination laws that will apply, that continue to apply, and they're listed there. There's also state discrimination statutes as well. Here in Idaho, it's the Idaho Human Rights Act. So the rule states that an individual shall not, on the basis of 6 grounds, race, color, national origin, sex, age, or disability, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any healthcare or health program or activity, any part of which is receiving federal financial assistance, including credit, subsidies, or contracts of insurance, or under any program or activity that is administered by an executive agency or entity established under the Affordable Care Act. So the rule doesn't preempt or replace other discrimination laws, as I mentioned, and it doesn't include a religious exemption, but it doesn't replace other federal and state protections for religious freedom either. The protection against the discrimination based on sex includes gender identity, where you have to treat persons consistent with their gender identity. However, back in December of 2016, there was a federal judge issued a nationwide preliminary injunction against the enforcement of the non-discrimination provisions for for transgender and against the termination of pregnancy. That was in the Franciscan Alliance versus Burwell case. Last year, in May, the Trump administration made a filing on the case asking that it be remanded back to Department of Health and Human Services because the department was considering altering the language. Now, I haven't seen any follow-up or know of any news after that. So we just need to stay tuned and find out where this goes. But in the meantime, that injunction remains in place. So who do these non-discrimination rules apply to? Well, covered entities, any entity that receives federal financial assistance from HHS, and that would include Medicare, Parts A, C, and D, Medicaid, any grants, federal loans, federal subsidies. It doesn't include Medicare Part B, which is relates to durable medical equipment, ambulance services, and research. So basically applies to hospitals, nursing facilities, clinics, medical practices, physicians, health programs that HHS administers, and health insurance marketplaces, and insurers that participate in the marketplaces. The basic requirements are: 1, you signed an HHS assurance form. You promise to comply with the rule. If you have 15 or more employees, you must also appoint a compliance coordinator and establish grievance procedures. You must post a notice of non-discrimination, and that notice must include taglines. And you've got to put statements in significant documents. I'll talk about that next. And you cannot discriminate on the basis of the 6 grounds. You must treat people equally in health care that they receive, treat them consistent with their gender identity, provide language assistance, and that includes interpreters, translations, to persons with limited English proficiency, provide auxiliary aids to those with disabilities, and finally make your newly constructed and altered facilities accessible to those with disabilities. Lots of rules, lots of requirements. Let's dive in and begin with the notice requirements. There are 2 types of notices that you need to have. There's a notice of non-discrimination. There's a statement of non-discrimination. This chart here just sets up a summary of what's required in each. We'll talk about each one. For your notice of non-discrimination, the notice must list the following 7 elements. It must state that you don't discriminate based on those 6 enumerated grounds. You've got to state that you, the covered entity, will provide auxiliary aids free and timely to persons with disabilities. You have to state that you provide language assistance, which would be interpreters and translations, again, free and timely. How to obtain the auxiliary aids and services, how to get in touch with your compliance coordinator, how to file a grievance, and finally how to file a complaint with the Office for Civil Rights, or OCR. Now, luckily, hhs.gov, their website is a great place to find sample notices in particular, and then also all kinds of other forms, guidance, information to help you comply with this complex rule. If you haven't discovered it and love it yet, I suggest you jump on that website and take a look around, get to know it well. It is helpful. On your notice, it only has to be in English, although the HHS doesn't encourage you to post the notice in 1 or more other prevalent non-English languages in your area. You still have to post those taglines in the top of the top 15 non-English languages. Now, in addition to the notice of non-discrimination, you must also have a statement of non-discrimination, and that statement goes in to all small-sized publications of the covered entity. And there's an example there of what it has to say. It just says you're not going to discriminate on the basis of those 6 enumerated grounds in your health programs and activities. It has to be in English, but this time around it's accompanied by 2 taglines in 2 of the top non-English languages, as opposed to the notice of non-discrimination where you need 15 taglines. So what are taglines? Well, it's a short statement written in non-English, which informs the person that language assistance services are available free of charge. There's the example that you can use. And remember, for notices of non-discrimination, you need that tagline in the top 15 non-English languages, and for the statement in the top 2 languages. And we'll talk shortly about where you post this notice. But generally, it's in physical locations where you interact with the public, on your website, and in significant communications and publications. And these taglines have to be the most, 15 or the 2 most prevalent languages in your state where you're operating. And if you're operating in more than 1 state, then in each of the relevant states. Now, even if you're in multiple states, you only need to have 1 set of taglines. And of course, the hhs.gov website, on the OCR website, there's published a list of the top 15 non-English languages in every one of the 50 states. So that's a great place to go. And in addition, on the HHS website, you can actually get translated taglines already done, ready for you to cut and paste. And as I mentioned, that website is great. Got the sample notices, translated documents, more training materials, everything you need to comply with notice. So where do you put, where do you post the notice? Where do you post the taglines? Well, all covered entities must post the notice and the tagline in the top 15 languages in a conspicuous place, visible font, and it's got to be in a place, physical location where you interact with the public. It's got to be on your website. You've got to be able to see it on the website, although you can just have a link to it. And it's got to be in significant publications and communications to the public and patients. So what does significant mean? Well, it's interpreted broadly, and it'll include everything from outreach, education, marketing, documents, patient handbooks, rights and benefits, consent forms. And a subset of that significant is vital documents, which we'll talk about shortly, and that comes under the limited English proficiency guidelines for translations. You do have some discretion on how you post the notice and the taglines. You can combine it with other notices. You can have inserts in documents, and you can have separate web pages. But the bottom line is, it's got to be conspicuous and visible so that people can reasonably be expected to actually find the notice and be able to read it. For statements of non-discrimination, those go into the small-size publications. What are those small publications? Well, it's things like postcards, trifold brochures, and in there you just need to put the statement and then the taglines in the top 2 non-English languages of your state. That leads us on to persons with limited English proficiency. Under the rules, a covered entity must provide free, accurate, and timely language assistance for persons with limited English proficiency, or LEP persons. And that's determined on a case-by-case basis. And in particular, you need to offer interpreters and translations of written documents. So we'll talk about interpreters first. Interpreters have to be qualified. And what does qualified interpreter mean? Well, whether you're providing, being an interpreter through a remote interpreting service or in person, one, you've got to adhere to ethics principles, confidentiality, keep things confidential that you interpret. You've got to demonstrate a proficiency in speaking not only English, but the language, the relevant spoken language. And you've got to be, you've got to be effective. You don't have to be licensed under state law, but again, proficient. And, even if you just have average familiarity or an understanding of the foreign language, that does not make you necessarily an interpreter. If you visited a country for 2 months and picked up some of the language, that's probably not good enough. And again, the goal is to try and provide reasonable steps to provide meaningful access to LEP persons. Now, if you're going to use a qualified interpreter through video remote interpreting services, you've got to make sure that that video remote service it actually has a good connection. It's going to be high speed. It's not blurry. You can actually see the person who's interpreting. You've got to see their face. You've got to be able to hear that person. And you've got to have somebody there who knows how to work that video remote interpreting service. If it breaks down, you've got to have someone there to repair it, who understands the technology. Now, with respect to interpreters, a covered entity cannot require the LEP person to provide their own interpreter. You also can't rely on any adult that's accompanying the individual with limited English proficiency to interpret. However, there are 2 situations where you can use an adult who's accompanying that LEP person. That's in an emergency, and there's no other qualified interpreter around. Or when that person with the limited English proficiency specifically request that that adult accompanying them be the interpreter. And then that person agrees, and it makes sense under the circumstances to allow that adult to interpret. You can never have a minor, a child, to interpret, again, unless it's in the case of an emergency and there's just nobody else who can provide that assistance. You also can't rely on staff who may happen to know another foreign language, other than qualified staff whose job it is actually to provide this interpreter service. It's got to be written right into their contract, and it's part of their job responsibilities. And again, even when it's written into their job description, and they've got to be proficient, understand both that English and one other spoken language, and they've got to be effective and accurate. Now, you also need to provide translators so that you can translate written content. Qualified translators are, again, similar to the requirements under the interpreters, where they've got to adhere to ethics principles, confidentiality. They've got to be proficient, and they have to be proficient in written English and one written non-English language, and be able to translate effectively and accurately. And just because you're a qualified interpreter doesn't mean that you're a qualified translator. You could speak it very well, but really you have a problem with, translating onto paper that language. Now, if you're going to use an automatic translation technology, HHS cautions against that, because a lot of times, I think probably all of us have tried to translate some phrase at some time or another online, and a lot of times they don't get it right. In fact, it's completely wrong. So if you're going to use that, you do need an actual qualified translator to double check the translation. So I spoke a little bit about vital documents earlier, about where you have to put the statement, the notice of non-discrimination. Well, in this situation with LEP persons, you need to translate vital documents, which are vital to the services. And if you don't translate it, there'll be consequences, especially if it's not accurate and timely. These are things like consent forms, notice of patient rights, complaint forms, intake forms. But you don't have to translate things like, the menu, the hospital menu, patient satisfaction survey, documents that are not vital to the services you're providing. Now, the rules do provide for a safe harbor with respect to translations, where if you do the following, that'll be strong evidence of reasonable compliance. And it's about, translating vital documents for LEP groups that are 5% of the service population, or 1,000 people, whichever's left. Or fewer than 50 persons in that group, that reaches 5%, you can provide written notice of the right to receive oral translation. We have to keep in mind with all of this and the safe harbors and doing all of this is that translations are expensive, they're not cheap. I looked just this week to see what it would cost, and it's up to 25 cents a word and $150 a page or more. So what can you do to, effectively and efficiently comply? Well, you can standardize and share the translated documents. And there's many government websites that'll have translated documents that you can use. You can also use qualified community volunteers. That brings us to persons with disabilities. So under the rules, the definition of disability is as follows, where with respect to an individual, a physical or mental impairment that substantially limits one or more major life activity of such individual. And it's a record of such an impairment or being regarded as having such an impairment. And the rules also go on to define what a major life activity is. So If the disability affects just one of the following, but it's not limited to, things like, eating, sleeping, walking, that will be a disability. And in addition, if the disability affects a major life activity that involves a major bodily function, so it affects reproductive function, circulatory functions, again, that will be a disability under the definition. And the definition is construed broadly, and only one major life activity need be limited to be a disability. And even if that impairment is episodic or in remission, it's still considered a disability. And even if you're trying to mitigate the effects of that disability, it would still be a disability. Now, if you got contacts or glasses, that is not a disability. So, for persons with disabilities, you've got to take appropriate steps to ensure that communications with individuals with disabilities are as effective as communication with others in health programs and activities. And it's got to be in accordance with standards found at 28 CFR 35, 160 to 164. First off, you've got to provide appropriate auxiliary aids and services for persons with impaired sensory, manual, or speaking skills to afford them an opportunity to benefit from the service. You also have to post another notice. And on that notice, you've got to state the individual's rights with respect to disabilities, namely that the covered entity provides appropriate auxiliary aids and services, including interpreters and individuals, interpreters for individuals with disabilities, and information on in alternate formats, and that they're actually free and they'll be provided timely. Now, you also have to take appropriate steps to ensure communications with patients with disabilities or companions with disabilities. So, if the person has a companion with them and they have a disability, you need to accommodate that companion, and that can be a family member, a friend, or associate who's with the person. Now, the type of auxiliary aid or service just varies in accordance with, the kind of communication used by the individual, the kind of communication involved, and if the person with the disability requests a certain aid, you've got to give primary consideration to that. Again, it has to be timely and protect the confidentiality of that person. The Department of Justice has suggested that, you can use interpreters, or that it's most likely you will need interpreters when you have to convey complex information. There's some examples: diagnosis, psychotherapy, counseling, treatment options. The rules also list examples of the type of auxiliary aids that you can use and that are appropriate. One for the deaf or hard of hearing. There's a list, and then also for blind or low vision. Some examples of the aids you can provide. Qualified interpreters, when they're used for persons with disabilities, again, whether it's via remote interpreting service or in person, they have to adhere to the ethics principles, confidentiality. They've got to be able to interpret effectively and accurately. Very similar to the requirements for interpreters for LEP persons. And again, interpreters for persons with disabilities don't need to be licensed, but they've got to have the relevant proficiency. Again, whenever you're thinking about what auxiliary aids to provide, you can consider these factors. Things that kind of pop out are the nature of the treatment, the size of your practice or facility, what makes sense, how many auxiliary aids are going to provide, how much are alternatives, what have been the patient's preferences for aids, and how many patients do you think will actually require the aids. Now again, a covered entity can't ask the person with a disability to bring an interpreter, their own interpreter. Can't rely on the adult accompanying the individual with the disability, except in emergency situations, or when the individual specifically asks that the accompanying adult be the interpreter, and the interpreter and the adult agrees, and it makes sense in the circumstances. Again, just like with respect to the LEP persons, you cannot rely on a minor child to interpret or facilitate the communication, except in emergency situations. And not only that, but where there's just nobody else who could provide that to be an interpreter, a qualified interpreter. If you're going to use video remote interpreting, BRI services, again, just like the LEP persons and video interpreters. If you're going to use the video, the audio has to work, the video has to work, and you've got to have somebody there who can understand the technology and make sure it works. If you communicate with patients by telephone, you must have the text telephone or equally effective telecommunication systems so that you can communicate with individuals who are deaf or hard of hearing or have speech impairments. And also, you need to use automated, if you use voicemail or messaging, you must provide effective real-time communications with individuals using auxiliary aid and services, including the text telephones. You've got to ensure that the persons with impaired vision or hearing, can obtain information as to the existence and location of these accessible services and activities and facilities. You've got to have signage at all inaccessible entrances so that you can tell them where the accessible entrance is, or direct them to a place where they can obtain information about accessible facilities. And of course, you do need that international symbol for accessibility at each accessible entrance. You've got to post that, post the symbol of the person in the wheelchair in the blue square everywhere. And that's why you see them at every entrance at public facilities. Now, you don't have to take every action or use every auxiliary aid, and you're not required to take any action if you can demonstrate that it results in a fundamental alteration of your service that you're providing, or it just is financially burdensome or administratively burdensome. You have to prove that, but those are two ways that where you don't have to take an action required or requested. However, you have to take another action. You've got to do something that would not result in such an alteration or burden, so that you can ensure that to the maximum extent possible, individuals with disabilities do receive the benefits or services. Now, there's also in the rules facility accessibility standards. They're very technical, and it depends on the date in which you are altering your facility or constructing your facility. In particular, if you're building or altering after July 18, 2016, then you've got to be compliant with the 2010 Americans with Disabilities Act standards and comply with the requirements for a public building or facility as defined in the 2010 standards. There are exceptions based on dates, and I won't go into detail there, but suffice it to say, if you're going to construct or alter a healthcare facility and you're a covered entity, you need to comply with these facility accessibility standards. The rules also require you to have technology accessibility standards. Not only that, all programs and activities provided through electronic and information technology must be accessible to individuals with disabilities, unless, of course, it would impose undue financial or administrative burdens, or it results in a fundamental alteration of the nature of your health program or activity you're providing. But if it's unduly burdensome, again, you can't do nothing. You've got to provide the information in a format other than electronic, so that does ensure that the individuals with with disabilities can receive the benefits and services that were provided through the technology. In particular, the rules state that their health programs and activities provided through websites have to comply with the requirements of Title II of the ADA. Now, the ADA website does provide guidance on website accessibility and toolkits, so you can comply with Title II. The HHS didn't actually specify website accessibility standards when it issued the rule, but it said in particular that it would be difficult for a covered entity to comply who did not adhere to standards such as the WCAG 2.0 AA standards or the Section 508 of the Rehabilitation Act. And the HHS encouraged compliance with these standards. So first off, what is the WCAG 2.0 AA standards for website accessibility? Well, those standards were developed by a private consortium of experts, and they were called the Worldwide Web Consortium, W3C as they're known. And when they created these website access standards, it was actually adopted by the U.S. Department of Justice in their settlement agreements. It's the legal standard for airline websites under the Air Carrier Access Act, and the DOJ indicated just recently in one of its advanced notices of proposed rulemaking that the WCAG 2.0 AA should be the legal standard for websites, or for those websites. Now, I just read an article yesterday which was interesting. It commented that there's been a real spike in lawsuits against healthcare facilities and public entities under Title III of the ADA. Title III states that almost anyone who lives with a disability can sue a place of public accommodation, which includes hospitals, physician practices, clinics, and other healthcare entities open to the public, for a perceived failure to comply with the ADA's requirement to accommodate disabled customers. And in fact, the article stated that the website accessibility litigation in 2017 saw a major spike. There's about 800 federal suits and over 100 state court suits. And one trial in particular involved website accessibility or inaccessibility. That was Gill versus Winn-Dixie stores. And in that case, the federal district judge, and this was in Florida, he concluded that the grocery store chain's website was inaccessible to visually impaired individuals, and that it violated Title III of the ADA. And the court ordered Winn-Dixie to conform the website to the its website to the Web Content Accessibility Guidelines, the WCAG 2.0 AA guidelines. So it's important to make sure your websites are accessible for persons with disabilities. And again, you can go to the WCAG website, to the W3G or W3C website. You can go to the ADA website for guidance, and it is helpful on how to make sure your website is accessible. And you've also got to make reasonable changes to your policies, your practices and procedures. Make sure they're up to date, so that ensures that you avoid discrimination on the basis of disability. So who enforces all of these rules, these non-discrimination rules under the ACA? It's the OCR, the Office for Civil Rights. And they've been receiving and investigating discrimination complaints since 2010. Now, the other statutes can also come into play when you breach any of these ACA rules. And the type of enforcement mechanisms that the OCR employs are things like requiring the covered entity to keep records, submit compliance reports to them. The OCR can also conduct a compliance review and an investigation. And if it's a serious non-compliance and you can't correct it informally, then they may, they have the right to suspend or terminate or refuse to grant or continue federal financial assistance, like Medicare and Medicaid. They can also refer your noncompliance to the Department of Justice. And they can recommend that the DOJ bring proceedings to enforce the compliance against you. And then any other means authorized under law. Types of damages that you can that can come down on you for noncompliance are compensatory damages. Individuals can file a complaint through the OCR or bring civil challenges for Section 1557 ACA non-discrimination rule violation, just like I mentioned with respect to your website and accessibility. Here's some examples of enforcement, just recent ones, not too recent, but they're kind of closer to our location here in Idaho. A lot of times you'll sign a voluntary resolution to agree, to fix the problem, and you'll then agree to report to the OCR and confirm that you are in compliance. Final topic today is service animals. And service animals are not to be confused with emotional support animals. And yes, there was actually a turkey who rode on an airplane recently, an emotional support turkey. So service animals are actually defined under the Americans with Disabilities Act. And a service animal under the Act is a dog. Only dogs. Recently they've revised the Act to allow also miniature horses to be a service animal in certain situations. But mainly it's just dogs. And dogs that have been individually trained to do work or perform tasks for an individual with a disability. And the tasks performed by the dog must be directly related to the person's disability. And as it says on the slide, before March 2011, it wasn't confined to just dogs. It could be any animal trained to do a task. So back then you could have rats and monkeys and cats who would perform these functions. But today it's only dogs and miniature horses. State and local laws will also, or they may have their own service animal laws and ordinances, which may define a service animal more broadly. But we're just talking about the ADA service animal for this presentation. Under the ADA service animal provisions, a covered entity or public entity or public accommodation entity must allow service dogs to accompany a person with a disability in all areas where the members of the public are allowed to go in the facility. Now you can prevent a dog from coming on the premises or limit the access if it's out of control and the handler can't control it, or if if the dog isn't housebroken, the dog is leaving presents all over your facility, you can prevent their access. Or if the dog poses a real risk to the health and safety of the facility and of the patients and the people inside. For miniature horses, you can also limit their access if the facility just cannot accommodate the size and the weight of the horse. You can require a dog to be on a leash unless it interferes with the service. But as for questions you can ask a person who comes in with a dog, you can only ask two. One, whether the dog is required because of a disability, and two, what tasks the dog is trained to perform. So there's a difference between the service animals and these emotional support animals, and I thought I'd just touch on emotional support animals briefly just at the end here. They are not considered service animals under the ADA, so they are not protected under the public accommodation provision of the ADA. Emotional support animals are animals who haven't been trained to perform a specific job or task. They provide comfort to the person just by being around them. They can be any type of animal, and a lot of times you can get, you can have a physician or therapist determine that the patient needs an emotional support animal and will prescribe to the patient that they go obtain one. Having said that, there are actually two federal regulations that provide some protection for emotional support animals, but it has to do with housing and transportation. Under the Fair Housing Act, A property management company can't deny housing to someone who has an emotional support animal. And then there's the Transportation Act, which allows emotional support animals on airplanes. Now, just this week, actually, I found out and read that there's been some pushback on emotional support animals on planes. This is kind of a tangent, but I thought it was interesting. The Department of Transportation, just this Wednesday, said it's not going to penalize airlines if they refuse to let passengers take aboard more than one animal or demand assurance that they have a disability, or if they require proof of the animal's vaccination and training. And they can impose reasonable restrictions on movement of that animal on the plane's cabin. Just because, just in recent months and last year, there have been some abuses of bringing animals onto the airplanes. And in fact, United Airlines and Delta, they've put in place some restrictions now. They have actually banned certain animals totally from traveling in the cabin. And when I read this list, what you have to realize is probably someone tried to do this and did it, and that is why these specific animals are listed. Hedgehogs, ferrets, insects, rodents, snakes, no more snakes on a plane, spiders, amphibians, sugar gliders, and non-household birds. And they've also barred animals with tusks, horns, or hooves, except, of course, trained miniature horses who are service animals. That brings us to the action items. What can you do to ensure you're complying? Well, you just need to be diligent. Watch for additional guidance on the HHS and OCR websites. You've got to train new employees, periodically retrain current employees, and you've got to monitor that compliance. Respond to complaints. I guess the key is ongoing training. I've listed some places in the next few slides where you can go to get the guidance and assistance to ensure you can comply. Again, like I mentioned, hhs.gov, wealth of information. We provide translated resources for covered entities. And then there's some websites, the OCR website, the ADA website, lots of help out there. Which brings me to the end of my presentation. So I want to thank you again for joining me today. And again, I'm Robert Lowe at Holland Hart. I've enjoyed speaking with you today, and I hope that you have a good rest of the day. Thank you.